So speaking of things to alter your mind, we're going to talk about marijuana today. I know this is a hot topic for all of you, just as citizens of Missouri. And then from an employment perspective, I'm going to focus on the employment perspective today. And I'm going to go through the slides. And then, like Matt said, we're going to hear from the city attorney for Lee Summit to talk about some specific Lee Summit ordinance issues. And then we'll open it up to questions because I'm sure you will have them. So Mary Jane, one of my coworkers did not know that that was kind of code for marijuana. I think most people in this room know that. A quick disclaimer, like Matt said, I'm a partner at Fisher Phillips. We are a labor and employment law firm. All we do is represent employers and management in all aspects of employment. So I know he was rattling through the things that we do, and it's a lot because there are so many issues that affect employers, and we're talking about discrimination, marijuana, workplace safety, we do it all. Some of you may know Lauren Sabaski. Lauren is, Sabaski, excuse me. She is one of my partners in our Kansas City office, and she's a member of the board. So both of us are here and up to date on what's going on with Missouri marijuana, so we'll both be available to answer any questions that you have. This is for informational purposes only. The rules of ethics require that I give you this disclaimer because I don't think any of you are my current clients, so we don't have an attorney-client privilege relationship. So this isn't legal advice. Also, Fisher Phillips is marijuana neutral, right? I know people have very strong feelings about cannabis and other derivatives of the marijuana plant. We're neutral. We're just here to provide the information. Okay, so we're going to talk about Amendment 3. Most of you, if you went to the voting booth last November, voted on this question if you are a Missouri resident. I think most of you are. It was on the ballot, and this was a constitutional amendment to legalize recreational marijuana. And you may remember that marijuana was legalized in a medical use back in 2018. And what a lot of people don't know is that Amendment 3 actually modifies what was passed back in 2018, which was Amendment 2. And so that's what I'm going to focus my efforts on today. So it was on the ballot in Missouri in November. Legalized recreational marijuana in Missouri for adults over 21. And it actually amended the Missouri Constitution to provide, to actually take away the prohibitions on buying, possessing, and selling marijuana in Missouri. And it also affects expungement of certain nonviolent marijuana offenses, and also allows individuals who are incarcerated for certain marijuana offenses to petition to be released from prison. So how did we get here? So Amendment 2, that's what I just talked about, that was in 2018, and that was the amendment that added to the Missouri Constitution legalizing medical use of marijuana. And so it gave qualified patients, which is defined under that law, the legal right to buy, possess, consume, and grow medical marijuana in the state of Missouri. There were limitations to that. I'm not going to bore you with those details. So Amendment 3 is what passed back in November, and that expanded Amendment 2 and legalized the personal use of marijuana by adults 21 and older, and contained some provisions that apply to employers that was absent in Amendment 2. So I know Lauren and I and the rest of the attorneys at our office were very grateful for that because it's been a little bit of a gray area in terms of how employers are supposed to handle these types of issues in the workplace and whether you have employees that are using medical marijuana. So what was expanded and added? So individuals who are currently incarcerated for marijuana offenses, they can petition for release. Individuals with certain nonviolent marijuana offenses can have their records expunged. It affects the reporting requirements of applicants with marijuana convictions, and then it also imposes a 6% tax on sales. But the most significant, in my view, that affects my job as an employment attorney is that it addresses drug testing and employment. So sales started last Friday. They were originally supposed to start on Monday, and someone sped it up, just couldn't wait, I suppose. So Missourians 21 and up, they can have up to 3 ounces in their possession. For those of you who aren't familiar with with marijuana and what it looks like and the weight of it, here you go. So an ounce is quite a bit bigger than a quarter. And so the bottom graphic there is the maximum amount that you can have for recreational use as a Missouri resident. So this was a article that was published, or a news story that was published yesterday. So in the first weekend, so we're talking Friday, Saturday, and Sunday, there was almost $13 million in marijuana sales in Missouri, which is huge. Now I don't think it's going to continue at that clip, right? It's not like every 3 days we're going to have an additional 13 million in sales, but just goes to show that the voters wanted this and the voters got what they wanted. Has anyone driven by a cannabis shop and seen people waiting in line? On Saturday, everyone that I saw, there was a line out the door. I don't know if that's still the case, but there's all kinds of goodies you can buy. Edibles, brownies, anything that your heart's content. So currently, under Missouri law, if someone uses marijuana on the job, unfortunately, there's nothing you can do about it. They can come to work high, they can work high, and just blame the Missouri legislature. There's nothing you can do about it. Just kidding. You guys looked horrified. But that's a question that we get a lot. See, us lawyers aren't always boring.
You go, girl.
Thank you. But that's a question that a lot of people have posed to us, and it's not really that unreasonable, right? Because you're like, okay, it's legal, so what can I do? You can do a lot, and so we're gonna go through what that looks like. So first, let's talk about what the law says. So so what Amendment 3 did to Amendment 2, so how the legal recreational law changed the medical marijuana law, is it added protections for those who are qualified patient card holders. So that's a graphic of what a qualified patient card looks like. The law says that employers are prohibited from discriminating against or taking adverse action against an employee who has a valid medical patient ID card. And there are 3 main areas that need to be focused on in terms of where you can't be treating those with those cards differently than those without. So you're prohibited from basing on the employer or applicant's status as either a qualified patient or a primary caregiver with a valid identification card. You're prohibited from discriminating against those employees or applicants based on that status, right? Also prohibited from discriminating against employees or applicants for their off-site use of marijuana during non-working hours. And then you are also prohibited from discriminating against employees or applicants who test positive for marijuana in an employer-administered drug test. But don't freak out, there's exceptions. So this does not apply, and this is the big sticking point that I think a lot of people don't realize, and this provides a lot of, I think, comfort for employers that were really uncertain about what they were going to do with, all their employees smoking pot and driving the forklift high. So this does not apply to employers who would otherwise lose a monetary or license-related benefit under federal law. So does anyone here have employees that are covered under the DOT? Okay, yeah, so under the Department of Transportation covers a lot of employers, certainly those that operate large vehicles and are crossing state lines and interstate commerce. There are specific laws because remember, even though marijuana is legal in Missouri, it is still prohibited under the Controlled Substance Act, right? It's considered a controlled substance under the federal law. And that's why, if you've been keeping up to date with this, all of the marijuana and cannabis businesses, they deal in all cash. And that's because banks and credit unions are governed by the FDIC, which is federal law. And there's lots of other reasons why, but that's one of the main ones that comes to mind. So if you would lose your license or other type of benefit in your business as a result of employing someone that is a medical marijuana user. That's an exception. Also, if the employee used, possessed, or was under the influence of medical marijuana at work or during the hours of employment, or under a circumstance where the legal use of marijuana affects the ability to perform job-related employment responsibilities, or affects the safety of others, or conflicts with a bona fide occupational qualification that is reasonably related to the person's employment. So what does that all mean? Okay, so the biggest question I think that we have been getting as of late is how you're going to be handling your drug testing policies. So we're going to get into that in a little more detail and explain kind of what you've been doing probably before and things that you need to think about doing on a going forward basis. So the short answer for all of this is you are not required to employ someone who is under the influence of marijuana. You're not required to allow anyone to smoke pot on your facility or ingest edibles. That remains the same in Missouri. But there are protections for those who use medical marijuana for a legitimate medical purpose off-site, right? And what we have entered and are trying to grapple with as attorneys is there's not any test readily available, or at least that I know of, or if I did, maybe I'd be a millionaire, but there's no current test that an employer administers that says, okay, I'm under the influence right now of marijuana. And marijuana stays in your system for a considerable amount of time. And there's all different factors that can control how much marijuana shows up in a drug test, right? It could be the frequency of use, could be the size of the person, metabolic concerns, all of that. But if I get into an accident at work and there's reasonable suspicion that there's really no reason I should have gotten in that accident unless I was impaired in some fashion, you can still drug test that person, or me, I'm using myself in this example, pursuant to your reasonable suspicion drug testing policies. But what's difficult is if you go and send that person to get drug tested and pot comes up in their drug test, what if they got high 2 weekends ago, had nothing whatsoever to do with your employment, had nothing to do with their job duties? They haven't been high in weeks, and really, there's no way for you to demonstrate that that person was actually high at the time that they got into the accident. So that's one of the issues that we're grappling with right now, and the reason is because, like I said, the test, there's no current test. Yeah?
What's the implications of that with workman's comp insurance?
One more time, I'm sorry.
Workman's comp insurance?
The implications in workers, okay.
Because I know that if it's tested, most of the time workman's comp's not going to cover it if they come back with drugs in their system.
Yeah, and the same remains true. So if you've got someone who was in an accident and the post-accident drug test shows up that they have marijuana in their system, workers' compensation can deny benefits based on that. Now, if that person was, a qualified patient that has a card, there's protections in terms of employment, and for a workers' compensation carrier, Lauren, I'd have to think about that. It would be, the workers' compensation carrier is going to have the same struggles that an employer is going to have, in that if they've got marijuana in their system, it's difficult to tell whether they're currently impaired. And so there's impairment factors, and we'll talk about that. But I don't know the answer to that. Have the work comp laws been modified at all to reflect the protections?
The work comp laws have not, but I think a good takeaway from here is that there is a statutory requirement that if you are going to take a workers' compensation benefit reduction to what you're talking about, someone tests positive, I'm loud enough. If someone tests positive for THC in conjunction with an accident or injury, you have to have that language in your policy that says you will take a reduction in work comp benefits. So that if that's something that's missing from your current policy, make sure you evaluate that, and also reference your unemployment as well, that a person can be denied unemployment benefits if they test positive. I do think that there is going to be issue, and I've had this come up with some work comp attorneys, which is how do they take the reduction to demonstrate impairment, which is what we've been struggling with since 2018, that there is no such test that is reliable for employers to determine impairment level, unlike alcohol, which we can say you are definitively impaired if you reach X concentration.
Or even other controlled substances. I mean, some of the other, methamphetamines, cocaine, those types of things are not in your system as long, right? So there's, if someone has has an accident and they get tested post-accident, and one of those other drugs shows up in their test, there's more likely than not, based on whatever that drug is and the concentration, that they were actually impaired during the accident. Did that answer your question? Anyone else questions about work comp? And feel free to interrupt me, just raise your hand if there's something that I talk about that you want clarification on. So even under Missouri's law, you can still test, right? You can still perform drug tests. You can do it when you have a reason to believe that drugs may have been a contributing factor in the accident. You can drug test if you have reasonable suspicion that that person is under the influence of a drug. And then you can also still perform random drug testing so long as it's pursuant to your policy that you're going to conduct that randomly, and you actually have a set, it's random, but you have guidelines in how you administer those tests to make sure that they're not administered in any discriminatory format. Prescriptions. So if you have an employee who has a qualified patient card, that's not technically a prescription, right? Because even though it comes from a doctor, it doesn't get filled at a pharmacy, right? But just for use of our purposes today, we'll call it a prescription because it's just easier. But you want to be careful that you wouldn't ask somebody for a copy of their prescription for, their antidepressant, right, or their hypertension medication. So you want to treat this in the same fashion. Unless the employee says, hey, I failed that test because of this prescription, there's really no need for you to collect that information from your employee. And that's true for the card as well. If someone has a card, I recommend that you document that card exists. Have someone from your human resources department or whoever it is that is reviewing someone's suitability to work with a qualified patient card. Just make a documentation of it as opposed to actually collecting that information. As an employer, you may have medical information about your employees. If you're keeping that medical information in the same file as the rest of their personnel documents, stop doing that, separate them. Most people keep those separate, but it's kind of in that same line that you don't want to keep medical information of your employees unless you absolutely have to, right? It just opens up the company to issues you don't want. So what should you do? Like Lauren said, you want to make sure that you are reviewing your policies and procedures, and specifically your drug testing policies. So we're going to talk a lot, and we have been talking a lot about drug testing, but there are other areas of your policies that you need to review to make sure that they're consistent and they reflect this change in the law. A good example would be, I had a client who's in Missouri. They had a post-accident, or they had an accident, and really there's probably no way that this would have happened unless the guy was asleep at the wheel or under the influence of something. So pursuant to their policies and their reasonable suspicion policy, they sent the guy in for a drug test. And the red flag was he was delaying, claimed he was so dehydrated he couldn't urinate, even though he kept going out to his car, perhaps peeing in a bottle in his car. It was very strange, but he finally submitted to the test, and it was positive for marijuana and a pretty high concentration of it. But in their drug testing policy, it only identified drugs as illegal drugs, right? And so we were kind of grappling with that. I'm like, well, it's not illegal in Missouri right now, right? But thankfully, there was reference within that same policy to the Controlled Substances Act, and it is unlawful under federal law. So a very smart attorney that he confers with every day told him that's the argument we're going to make if we're going to have any type of concern. But overarchingly, he didn't have a medical marijuana card. So there was no protection under the law for us not to terminate that individual, right? But it was still a little hanky because it says, hey, if you have a post-accident drug test that comes back with an illegal drug, that's a basis for termination, right? And at that time, it wasn't truly illegal. So I suspect that a lot of you probably have similar language in your policies. So I encourage you to take a look at that and make sure that you are modifying that accordingly so that you can account for someone using recreational marijuana and there can't be some sort of, carve out. Good.
I was just going to say to make sure that they knew we did not draft that policy.
We did not draft that policy. Yes, we did not draft that policy, but I think we got a strong argument if it comes up. I don't think it's going to come up. I mean, the guy knew he messed up, and I don't think he's going to try to sue the company for doing anything unlawful. So take a look at your policies, take a look at your drug policy, and most importantly, make sure that your managers and your supervisors are trained on that policy, right? Because most of your managers and supervisors have been operating under the assumption that, pot's illegal and that's that, right? But the analysis doesn't end there. You need to make sure that if you're going to take action against someone for, having drugs in their system, whether it's at the application stage or they're a current employee, you want to make sure that you're accounting for these new protections in the law for those who have a qualified card. And we'll talk about kind of whether you decide, okay, so before we do that, who currently drug tests new applicants as part of your application process? Is that it, really? Okay, so those of you who have your hands up, how many include marijuana in the panel of tests? Have you guys had any conversation with any consideration about removing that from your panel? No? Has anyone removed it from their panel because it made it impossible to hire people? Don't be ashamed. I mean, yeah, and we actually have had to counsel a lot of our employers to remove that from the panel, or if their drug testing company is unable to remove it from the panel, that they not consider it as part of their qualifications for employment, because it just makes it really hard to find people. And I think things are starting to get better, but certainly I think most of you know that it's been very difficult in the last 2 years to not only recruit good employees, but to retain them. And sometimes, taking out that prohibition on marijuana in a system can help you get to where you need to be. So here are the instances that we see when an employer tests for drugs, right? Post-offer, pre-employment, that's the most common. Under reasonable suspicion, do you guys understand what I mean when I say reasonable suspicion? That you have, pursuant to a policy, and I recommend that you have this clearly defined in your policies, that you have reasonable suspicion to believe that that person is under the influence of some sort of substance that is causing them to get in the accident or behave in some manner that is not normal for that person. Random drug testing, post-accident drug testing, fitness for duty or return to work testing, and then also periodic testing. Does anyone in here do periodic testing, like on a regular interval? And what do you use that for?
Drivers, DOT.
Okay, yeah, that makes sense. Anyone else not covered by DOT that does periodic drug testing? Okay. Before we move on, any questions about when you test for drugs and when you're testing for marijuana? Okay. So here are kind of some options that we have given our clients, and then these presentations that we're doing about what your options are now that you've got employees that can do it legally, even if they're not coming to work under the influence and you're not smoking dope in the parking lot. It's a concern, right? So you can do nothing, right? Change nothing with your policy except making sure that you have a carve out in your policy for those who have a qualified patient card. Stop all drug testing. So we're not going to test for marijuana or meth or opiates or anything. Stop all pre-employment testing. Remove marijuana from the testing panels. That's an option we talked about. Remove marijuana from pre-employment panels. So you can have marijuana be prohibited under your policy and test it in a situation where you're under reasonable suspicion scenario, post-accident, and not test for that at the outset of the employment. Because that seems to be a common problem that our clients have, is getting people in the door, and it's not always in the sectors that you think. It's affecting applicants from working on a production line, landscaping, all the way up to executive level. And it's just because it's everywhere, and it's becoming a part of people's everyday fun. You can also test only specific occupations, right? It may be that in your business you have certain positions that are safety sensitive, right? They're operating heavy machinery, working with small children, something where you have a justified reason for making sure that person is never under the influence of marijuana or any other drug. And then maybe you don't care so much about some of the other folks, right? And that's been another option that we've seen some of our clients take, again, to help overcome kind of that void of qualified applicants for different positions. So we've talked a little bit about impairment, and this is kind of the $1 million puzzle that we need to solve. So it's a non-exhaustive list, right? This is just a few of the signs of impairment for some people, right? I mean, there could be people that, smoke a joint on the way to work and you would never know, right? That's just Ron. He's always really chill and we like him, okay? I mean, we don't know. We don't know. But here are some signs of impairment that you traditionally see for someone who is under the influence of marijuana or another drug. Anyone else have a potential sign of impairment that I didn't include? This should be fun. Going to the snack machine frequently. Anything else? Anything else? No. And so Lauren and I have been cautious on how to train employers and managers on what to do in this situation that we're talking about, where you've got someone with marijuana in their system and they have a qualified patient card, so you want to make sure you're not discriminating against them, but how do you measure impairment, right? There's just not a one-size-fits-all, and this law just passed, so I haven't seen any cases about this yet, any claims, any lawsuits. And this happens sometimes when a new employment law passes because the regulations aren't clarified. We don't have a court that's interpreted the law and come down one way or the other when things are ambiguous. And I will tell you, I had the actual language of the law pasted up there, and then it kind of makes your eyes cross because this is not very well drafted, or could be better drafted, I guess I should say. So some of this is kind of a wait and see. Has anybody, by a quick show of hands, talked about measuring impairment or determining whether someone is currently under the influence of marijuana? Yeah, I didn't think so. Not many are. It's so new, and it's just difficult to grapple with. So any questions about drug testing before we move on? Yes.
My son-in-law works for Evergy, and they're like, nothing, you can have nothing. Now, in the very beginning, we talked about how they can't discriminate for employment.
If you're a qualified patient card holder, yes.
Qualified patient card holder.
Mm-hmm.
Okay, so you have to have the card, and so Evergy would have to be okay with that. But he's like, oh no, nobody nowhere, no how in Evergy can have any kind of exception card.
Yeah, there may be some, I'm not really familiar with electric utility regulations, but it could be that there is some sort of federal regulation that governs whether or not they can permit that. But generally, and this is all very new, because employers can still prohibit having employees or applicants who use marijuana, right? Except in those instances where someone's a qualified patient card holder. And then again,
Like it's really hard to get a card.
yeah, it is not difficult to get a card from what I've heard. And now, I mean, at this, and most,
I'll give you one today if you want.
right, yeah, who's got one in their wallet? And now, even if someone actually does think that they need it for a medicinal purpose, they may not go through all the rigmarole of getting, not that it's very that difficult to get, but they may just go to their corner dispensary because they can get anything they want now because it's recreational. But in an instance where someone really is, maybe, because there are people who have chronic issues and cannabis really is therapeutic for them as determined by them and their healthcare provider. So there may be someone that, you know, even though it's recreational, obviously they're still going to have a card because of the protection in employment. So if you've got somebody who has a qualified patient card, they can't be using it while they're working for you. They can't be selling it out of their car. They can't have it on their person in your facility. That's what those exceptions were that I talked about earlier. So,
Could be covered in the federal, where no employees.
yeah, it could be, or maybe they're not, and their policy about medical marijuana just isn't that clear. Yeah, or yeah, about to change, right? Yeah, but that's a good question. Anyone else? Yes.
We fortunately haven't had to deal with it, but we've had a lot of discussions.
Knock on wood. It's gonna be tomorrow. I was teasing.
But we've tried to liken it kind of to liquor, and like, is smell enough to reasonable suspicion or something? Like, if someone showed up to my shop reeking of booze, I know I'm not gonna probably put them in the boot. But if they smell like pot, I don't know, could be that they just had their morning joint.
Yeah. But you know, if they just have their morning joint, then they're probably under the influence. So you don't want to put them, you know, behind the wheel of a company vehicle. But that's why, you know, we're encouraging employers to kind of take a long, hard look on how they're going to handle situations like that. Is it going to be, and we recommend that you have some sort of policy that outlines, okay, if I smell marijuana, what are these other things that I need to look for under our policy to determine whether or not we're going to proceed to our next step to determine if we need a drug test. And then have that policy and make sure your managers and supervisors understand that policy and make sure you're applying it consistently. Because as most people know that have ever dealt with any type of employment policy, it's only as good as how well you implement it, and you implement it consistently and fairly across the board, right? Because if you smell marijuana on Jim and don't do anything about it, but you smell marijuana on Sally, well, why'd you treat Jim differently, right? It's just a hotbed for potential discrimination claims. And that's a very oversimplified example, but it kind of starts like that, right? When you don't have policies that you're administering on a consistent basis. Even though you have zero intention for it to be treating a woman differently than a male, that's not required in order for them to bring a case against the employer. Initially.
So I would make a further recommendation that if you have signs of impairment, what I always advise clients is if you believe that someone is impaired, that's a conclusion that you have reached, right? So what are the tangible signs that led you to the conclusion of impairment? So have at least 2 managers or supervisor level employees document the tangible things that led you to believe the person was impaired. Did you smell it? Did you see it? Did they offer you some? I mean, what happened? Document those things, and then follow your policy about testing. So if you have reasonable suspicion testing in your policy, document those tangible reasons, then send them for a drug test, positive THC regardless of concentration, along with those tangible signs of impairment, could together give you the basis to say, you are likely impaired on my job, you likely do not work here anymore.
Mm-hmm. Yeah, and along those, that's a really good point, Lauren. And along those same lines, you know, as you're documenting these situations, you want to make sure that you're being descriptive and factual. And we run into this with all types of documentation, right? In a sexual harassment scenario, you might document that, you know, someone was being creepy. Well, what on earth does that mean, right? Same with this person seemed high. Okay, well, why did they seem high? And that's when you would want to outline what Lauren already discussed. You know, see, taste, smell, all of that, to give more context, because then, and document it, in time, right? Make sure it's documented exactly or as close to the observation as possible. Because in the event there is some sort of litigation down the road, juries really don't believe anything unless it was written down. And they don't really like if things were written down a long time after something occurred. It's less credible. So that's why you want to document these things. Yeah.
I also just wanted to point out that another misconception that folks have based on the news is that the law changed as of Friday. The law changed for employers on December the 8th. So if you have not already reviewed your policies on drug testing and how you are addressing that, you may have already violated the law. So understand that the law changed December 8th. Recreational access happened on Friday. That's what happened on Friday, not the law change, okay?
Yeah, there was a gap of time between the law changing and it being available for sale. Yeah.
Does it matter what size your business is? Can you have a business that is so small that none of these laws apply to you? Like, there are certain, no.
No. Good question, though, because there are lots of employment laws that matter based on your employee count. It's a good question. Yeah, even the small employer does not have to employ somebody who's high all the time. Yes?
How does it affect OSHA? How does it affect that?
When you say affect OSHA,
Like if there's an accident at work and OSHA, the kind of like with the workman's comp, but is there any effect of that?
yeah, there could be. So, what happens oftentimes that employer unfortunately comes across OSHA is there's some sort of accident and you're required by law to call OSHA. And OSHA shows up and maybe under your policy you have some sort of, or you probably do have some sort of post-accident policy and you send that person for a drug test. If you have a policy that prohibits employees from being under the influence at work or having marijuana in their system if they're not a qualified patient user, and then it comes back that that person, has marijuana in their system, then you as an employer may have a defense available to you. It's called unpreventable employee misconduct. And that is a defense available in any type of exposed hazard to an employee, and that is, we trained this person on what our policies are, they acknowledged, they understood what the policy were, there's no manager knowledge that that person was violating the policy. And as long as you can meet all of those, you generally can establish an employee misconduct offense. Yes?
I have another question. What if your corporate office is not in Missouri and you have buildings in 10, 15 different states? Does it go by whatever state the person's applying for?
That is a great question. So if you are a multi-state employer, I recommend that you contact Fisher Phillips to help you with a multi-state employment handbook. But what we typically do is we've got our set policies, and you would have a policy that only applies to employees that work in the affected state. So to answer your question, the law where the employee works is what governs. So if you're headquartered out of New York and you got a guy working in the field in Missouri, he's covered by Missouri laws. And that's typically true for all employment laws, but that's a really good question. Yes?
I guess my question really was, can you be such a small business that you can't discriminate against somebody hiring?
Not that I'm aware of.
There are other things in the past where I've been told, oh no, you have to be 50 and under, small enough that you don't have to follow these laws.
Yeah, so like FMLA, if you don't have 50 employees within 75 miles, you don't have to follow it.
Your business is 3 people, you still have to not be discriminating in the hiring practice.
Yeah, so presently there's no employee threshold is what we call that, but the law does give power to issue additional regulations, so there could be clarification to that point down the road, unless something has changed I'm unaware of, Lauren. Yeah, that's a good question. Yeah, like the Missouri Human Rights Act, it only applies to employers with 6 or more employees. So if you had fewer than that, that law would not apply to you, but no, there's no employee threshold for marijuana. Okay, so I'll get through this because I know we've got another presentation. So another thing I want you to be aware of is as part of Amendment 3 passing, individuals many individuals have their records expunged, right? But it's going to take some time to get through that and for the processing to occur. And so employees are not required to acknowledge that they have criminal history or answer questions in an application for employment about their marijuana-related offense. So what we envision may happen, well, let me ask this. Who asks at the application stage whether someone has been convicted of a crime? Does anyone do that at the application stage? Be careful in Kansas City, Missouri, if you're operating in Kansas City, Missouri, because you can't do that on the application. You got to make sure you're interviewing that person to make sure they're qualified before you can ask that question. But no matter what your stage of background check is in your application process, if you've asked that question and someone did not disclose it, but then you get a criminal history report that you've, with authorization have run on that employee, and it comes back that they actually did have a marijuana-related offense, because again, a lot of these are not expunged yet, and even if a offense is expunged, it may still show up on that criminal history report. But the fact that the employee failed to disclose that to you during that question, you can't use that as a basis to terminate them or to disqualify them from employment. You basically have to act like it never happened. Yes?
So from a licensing standpoint, when you apply for a license with the state of Missouri, that is one of the questions, have you been convicted previously? So what you're saying is, if somebody has been previously convicted of a marijuana charge in the past, that they can mark no?
Well, not necessarily. So when you say, what kind of license are you talking about?
So any license that you apply for with the state, real estate,
Well, it would really depend on that licensing bureau, how they treat that. So it may be that the real estate association has some sort of prohibition on licensing those who had a marijuana offense. I don't know if that's true.
Because the licensing agency is not the employment. They're not employing.
Right, that's a good point. So the person who's going to be, the body that's issuing the license is not the employer. So, when they're filling out that license, it's for the, National Association of Realtors, right?
actually with the state of Missouri, that's why I asked, like it's with the state of Missouri.
But the state of Missouri is not employing that person, right?
Correct.
Okay.
Giving them the license, so on that, they would still mark yes, if they had been previously and let it work itself.
Right,
Okay.
yeah.
Thank you.
But just make sure you're double checking, because every instance that's a really good question, but it may be different depending on whatever the license is.
So are people with non-violent marijuana, are they automatically being expunged, or do they have to go and do something to do it?
They're automatically getting expunged. It's just taking some time, to get all of those to work through the system and actually get them out of the files. And it's for non-violent, right? Because there may be someone that has a marijuana-related offense that's tied to a violent crime. That would be a different situation. Okay, so here's our 5-step plan, and then I will pass the microphone over. So I recommend you evaluate your current drug testing policies and your practices. Revise your handbooks and drug testing policies to account for your obligations under the law. Determine if in your business there are positions that could qualify for one of the exemptions to the qualified patient protections. Train your HR professionals and managers on having conversations with employees, determining how the medical marijuana law may affect your employees and the impairment concerns that we talked about earlier, and then also train your employees and your managers on the signs of impairment and make sure they understand what your policies are. Because again, I guarantee most of your managers have always operated under the assumption of your policy, because it's been that way, that no way, no how in the workplace. And while that's mostly true, like we've beat a bit of a dead horse here today, there are some exceptions to that. So I know you have to run, so I'll let him go, and then I'll be around afterwards if there's other questions.
I've been city attorney here for a little over 8 years, going on 9 years at this point. And the marijuana law is one of the really oddly bigger challenges we've had. As was stated earlier, this was passed in November. It became effective in December, and we knew that sales were going to start. I thought the 6th was when it was going to happen too, and it happened the 3rd. So we had a very short time in which to react to all of the different provisions. So you've been hearing about employment provisions. Employment is only one of my, I have a very short presentation for you. I just want to give you an update of kind of what we've gone through. But we've taken on our Indoor Clean Air Act because we have those issues with smoking and use in public places. We had to take on zoning. We had to take on our offenses chapter because, believe it or not, even though it is now technically legal in Missouri, it's not 100% legal. So we've had a number of things, including, I think I mentioned zoning. We've had to look at all the zoning aspects at this point. So where do we start with regulation? Well, this is our regulation parameter that comes from the law itself. And it basically says we cannot create any regulation that is unduly burdensome on the industry. However, within our authority is the time, place, and manner. So we have the authority to regulate within these parameters, and essentially an unduly burdensome regulation is one that would make it so difficult for that business to operate that no normal thinking person would ever want to engage in the business, basically. That's an oversimplification statement, but that's basically it. So we are talking about, within the business side of all of this, we are only talking about a fairly limited number or a limited range of authority that the city actually has. So where did we start? We started here, and this is our offenses chapter. And this is the places where things are still illegal to do related to marijuana. We did split apart in our ordinances. We had controlled substances, and included in that previously was marijuana. Well, now the rules for all other controlled substances are not the same as marijuana, so we had to split those apart. I'm not going to go into a lot of specifics with you all because Matt just wanted me to kind of give you an update, so I'm trying to keep this kind of short and sweet for you. But there are a lot of different ordinances that we did have to create and to split apart and modify. Possession is still potentially an issue. For example, if a person is under 21 years old, if you are in possession, you better have a medical card. And if you're under 18, your parents better have the medical card because it is still illegal for someone between, and we can only hear cases, 18 through 20, essentially. But it is still actually illegal. It is still considered an infraction in the state of Missouri. That is not one of the ones that a civil penalty applies to. As Samantha was talking about earlier, there are these purchase limits. I thought they were purchase limits, so I may have this wrong, that a person could go purchase 3 ounces recreationally, but you can possess up to 6 ounces before a civil penalty kicks in. So you can only buy 3, you can have up to 6. If you have 7, then you could have a, quote, civil penalty of $100 fine. It is not a crime. Very interesting way that they have kind of split this apart. With medical, a person could have 4 ounces, but if a person has medical 4 ounces, then they can have, another 4 maybe? It gets very confusing in the law because, as was indicated, it is a confusing law. Use in public in Lee Summit is just not permitted. That's the direction that we got from the city council, and that's the direction that we went. And my example here was a civil penalty. Smoking in public place has a $100 civil penalty that is actually applied in the constitutional amendment itself, which is so bizarre to have an actual penalty that is listed in the constitutional amendment. I'm going to take a pause, and for some of you that don't know much about the court system, I will tell you what you always hear about is criminal court and civil court, right? So somebody gets arrested, that's criminal court. Somebody gets sued for doing something stupid, that's civil court. But in Missouri, we have a third way. we have is what is considered an infraction or quasi-criminal. And that is where the municipal court comes in. So in addition to all of these other things, we were also trying to make sure that we got it right in municipal court. So technically, we can write you a citation for smoking in public place for $100. But if you choose not to show up in court, I can't issue a warrant to have you arrested because it's not a criminal offense. So, yes, I have a question. But
There's a civil penalty, you haven't committed a crime.
that's correct. It is a civil penalty, and it is not a crime. It's not even the quasi-criminal thing that Missouri came up with a long time ago to try to make it easier to have municipal courts. There's a whole history behind that I won't go into. But that was another complication of this law that we kind of got hit with as we were going through this. So we modified chapter 17, the articles related to controlled substances. We have also modified our Indoor Clean Air Act and our vaping ordinance. So smoking marijuana is prohibited in public places just generally. There is a provision in there that talks about smoking of marijuana may be prohibited in a location where tobacco is prohibited. So there's the flip of that somebody someday will bring a case on is, well, tobacco wasn't prohibited, but you prohibited me from smoking pot. So you shouldn't have done that. You violated my constitutional right. I fully expect to see that case someday. But so you all know the ordinances that we have drafted essentially place the same restrictions on smoking of marijuana as we have for smoking tobacco. We did the same thing with vaping. The restrictions that we have regarding vaping flow right over to using vaping for delivering your THC. So that's there as well. We also had to amend our business license chapter. You know, the city of Lee Summit has a business license program. Everyone needs to get a business license. The cost is generally very low for those licenses. But there were a whole series of different types of businesses that were added under this business. We had previously had medical facilities, and there were about, I think, 5 different types of facilities. Then we also created the sort of recreational facilities that mirrored those, plus something called the micro businesses that are a little bit different. So we have kept the rules the same, but we very quickly amended our code to make sure that we had all of the different types of businesses covered, so that when we did have this switch over to the comprehensive facilities, the dispensaries and so on, that we would have the regulatory scheme in place so we couldn't have someone claim, well, the hours of operation don't apply to me, or this or that doesn't apply to me because you don't have it in your code. We got it in the code, we got it done before the 1st of February. The hours of operation locally that have been created by our city council, 9 to 9 Monday to Friday, 9 to 6 on Saturday, and 10 to 6 on Sunday. We've already heard from the industry that they really don't like that Saturday time. That 9 to 6 p.m. time is not something that they're real keen on. There was a request of the council to lengthen that out, and the council did not do that when we were considering this very ordinance. So I have a feeling that issue's not dead, but as of right now, those are the times. We've already heard that there were some businesses that had to turn some people away on Saturday at 6 p.m. So fines and penalties, I talked about this a little bit. You can have civil penalties for violation of an ordinance or regulation governing time, place, and manner. Violations that can result in the civil penalties are improper cultivation, and by that, the constitutional amendment talks about someone is cultivating in view of the public. That is technically a violation that would create a civil penalty. Under 21-year-old possession of 3 ounces or less, I think actually that one is not a civil penalty. I think I have that incorrect. 21 years or over in possession of not more than 2 times the proper amount, then that will create a civil penalty. So you just had a discussion about expungement. Interestingly, and I don't know if this was intentional or if it was an oversight, but expungement does not apply to municipal charges. It does not apply. And I think that is going to come as a shock, that you could literally have had a large amount of that, attempted sale or whatever previously, and have a criminal violation in a county court and go to jail, and that can be expunged. But a simple small possession amount in municipal court is not eligible for expungement. The law is written in such a way it doesn't apply. We have gone back, double-checked that with the Office of State Court Administrator. They're the people who issue all the rules for the operation of municipal courts. They have told us emphatically that the law does not apply. So I will not be surprised if we see something come from the legislature or potentially from the Department of Health and Senior Services, because I think that was probably an oversight. So zoning, we have one interesting example of zoning here. The law allows for cities to have regulations prohibiting the location of these types of facilities, marijuana facilities, within 1,000 feet of an elementary or secondary school, child daycare center, or a church. You all may be thinking about, well, how does the one on North 291 by Walmart, how is it right across the street from a church? And it is. The reason is the next paragraph. It's the way it's measured. The measurement is by the closest legal walking path. And at 291 right there, there is not a crosswalk that goes from south to north. So you have to walk all the way down to Independence, across the street, and come all the way back down, and it creates a 1,000-foot walking path. So that's how that one ended up there. And it previously, this measurement was not in the law, but it was the rule that we adopted just ourselves because there was no rule in the law to tell us how to measure. So we had adopted this rule. This is what they came back with this new constitutional amendment, which was at least helpful because it did clarify what we had from the medical previously. And I say here, different uses go in different zones. The dispensary uses of the different types can go in most of the commercial zones, C2 and up, essentially. The manufacturing types, so the infusion facilities, the grow facilities, all of those are required to be in industrial zones. There are more industrial uses. We know that there is odor that comes from grows and some of the manufacturing facilities. So those are placed in what we think are more appropriate locations in industrial areas. So employment considerations for government, we're a little different. Not to say that anything at all was incorrect, and there is a ton of ambiguity in some of this employment stuff, but there is a specific exception in the law that says you can't discriminate unless doing so would cause you to lose a monetary benefit under a federal law. So as you all know, we hire police officers, we hire firefighters, we hire all sorts of different law enforcement, prosecutors, et cetera, and we receive grants from the federal government. And all of those grants end up with some statement requiring us to have a drug-free workplace. Now, I will tell you, there is a lot of discussion amongst cities right now as to what that means. So does that mean that you have to test for marijuana pre-employment? Do you have to do, what do you have to do in order to meet the drug-free workplace? I know of at least one city that has decided that they are not going to, the only people that they are going to random test and the only pre-employments that they are going to do from here on are DOT employees or safety sensitive. Safety sensitive is a classification that applies very strongly to us, and in many private instances it isn't going to apply to you so much, but for us, a police officer, a dispatcher, those folks are all going to be safety sensitive, firefighter, et cetera, et cetera. And, you know, since we hire people that can, sadly, and at times they have to, kill people and break things, I want to make sure that they're not high. If I'm handing them a gun, or I'm giving them a supercharged car, or a multi-ton fire truck to go rolling down the highway responding to a fire, I want to make sure that they are not under the influence. So with that one, as I said, it would be short. I'd be happy to take some questions. I see one back here.
So I hear you talking about things that are confusing and gray, et cetera. And there have been states that have been legal dating back to 2012. And so I'm wondering, was there any best practices in other states that you tried, or is Missouri just winging it?
You know, I don't really know where this amendment came from. I don't know who drafted it. It felt like when I was, what was that? Okay, yeah, maybe. It felt like maybe it was an amendment that had been drafted to fit the law of some other place, and then it came to Missouri, and it just sort of got shoehorned into what folks were trying to do, because it really doesn't fit very well. Like this whole issue with the municipal court and expungements, it just didn't occur to whoever did it because they either didn't know about Missouri law, or it doesn't exist in that way in very many other places. I don't really know of any, in fact, has the third type of law that exists out there. So I don't really know where it came from, but there is a lot of ambiguity. I mean, you can just call this the Lawyers' Full Employment Act for the next 20 years, because there's going to be lawyers arguing about a lot of these provisions for a long time. Yeah.
On your thing, you talked about just a civil penalty of $100. So basically, if I don't pay them the penalty, there's nothing happens to me. Is there ever a point where, you know, you show that, hey, this person's got 10 of them, so now they're up to $1,000, and then that could go into a situation?
You know, at that point, you're talking about a collections action. You know, you're talking about how do you go collect bad debt? And I don't think we're probably going to be doing that a whole bunch for $100, but if you do have somebody that has a whole bunch of these, maybe you go do that. I mean, it's all uncharted at this point. I don't know how those civil actions are supposed to work. What did they envision? Did they envision you do something stupid, we file some sort of information with the civil authority, with the civil court, so the county court, to try to enforce this penalty? It really doesn't make a lot of sense when you think about the way things really work. I understand the idea of trying to decriminalize and turn it into something civil, but when you just look at the logistics, it doesn't make much sense, and it doesn't work very well.
Those zoning distances you show to a school, to a preschool, all these things, is that the same for a bar?
You know, I don't know off the top of my head what a bar is. I would have to look. I think bars are actually a little bit shorter, my recollection, but I don't remember off the top of my head.
So that it's not the same, like.
No, they're not identical. I'm sure of that. I'm sure they're not identical. There is a long established body of law as to what happens with bars and different types of facilities that serve alcohol.